focus on the lawfulness, because the lawfulness, in my opinion, comes out of three things, which they could have demonstrated if indeed they existed, but they can't demonstrate because those things don't exist. Is there a charge anywhere which says they've been charged, they've been remanded? No, there isn't. Is there a warrant that remands them beyond the 3rd of February 2025? No, there isn't. That's why it hasn't been brought here. Is there any order of any court? That's the third point. Any court anywhere, even if it was an else court, that says remand, my lord, there isn't. So when we go back to the burden of proof, that fact, that is especially within the knowledge of the respondents, the reason why these people are incarcerated has not been brought forward. You have been treated to the argument that we are doing the best we can. The best they can be done when these applicants are enjoying their liberty. That is what we have here superfluous application is about. The moment they can't demonstrate this fact, especially if they are not, my Lord, we pray that you be persuaded by that the third point of which we agree with my last friend as important has not been proven by the respondent. The affidavit is here, my Lord, you read it. There are averments with no attachments, saying something, but nothing is also saying something, but nothing. This matter would have been very easily dealt with if there was a court order, the remand order, or a charge. Simple as that. We wouldn't have said much. We would have just looked at it and said, oh my God, this is it. Okay, we understand. If it isn't there, my Lord, I implore you, let the Constitution prevail. The Constitution must prevail over every circumstance. Unless we have reached a point where we are saying it has no meaning. And I'm asking, my Lord, respectfully, I'm asking respectfully that this court, yes, I'm addressing it directly. My Lord, I agree that with due respect, I am asking humbly, respectfully, that the Article 23 be allowed. Personal liberty is something which cannot be compared with anything else. Being incarcerated for lawful reason is terrifying enough. Being incarcerated for no reason at all has no place at all under this Constitution, unless we apply it, and we are not. So, my Lord, I rest that I respectfully urge the court to find our submissions in support of this application, convincing, satisfying, persuading enough for you to grant the order. That order, as my Lord can be granted extent order. Circumstances do sometimes face that. But that, my Lord, we will leave. That we will leave to the court. I thank you, my Lord.
Yes, my Lord. How many minutes? One, just one. The senior state attorney, apologetically, was never and we did submit about the decree which was sent to them on 17th of February, suggesting that they got it late. That one is very surprising because the applicants were not party to the Supreme Court. We are not here to enforce the Supreme Court decision. We are here, my Lord, to enforce the Constitution, which guarantees the liberty, whose restriction has not been justified. I think the only problem with the respondents is reading the Supreme Court decision in isolation of the Constitution, but also reading it mechanically. Mechanically, that they were waiting for a decision to say release.
Simplify what you mean. So that's our journalist
Well, my Lord, with your guidance, I will, although my primary concern is you.
but they consume and they help us
Sure.
share this information because it then manages the tension.
Thank you, my Lord. And I will do that.
Mechanically.
Mechanically.
Without thinking like a robot.
I refrain from saying they are not thinking from here. My Lord. I want to say they are thinking but mischievously. Mischievously because the foundation of the court decision is giving effect to the liberties guaranteed under our Constitution and not restrict them. So the way the Attorney General is interpreting this Constitution is mechanical in a sense that he uses it to achieve a particular end. And that particular end is to continue the detention. My Lord, Section 57 requires a detention order to be signed and sealed by a person authorized by law. So the question is, whose signature and seal exist on the detention order, if any? Which is, if it exists, it has been hidden from court. And that is intended to deny the applicants the protection of both the Constitution and court. My Lord, if someone is indefinitely held in custody, when do you come in to protect that person? As court. As court, you issue a warrant with limited timelines to ensure that this person is properly protected and is in good order. But what the Attorney General is treating us on today is to say, for as long as we are undertaking these administrative processes, it's okay. A violation is not acceptable in our constitutional framework, not even for a microsecond. Hello? But we are not even bothered about how long it takes the DPP, if she intervenes, or even the transfer process. We don't care. The DPP might even decide not to touch this file and say that file is a nullity ab initio. I will not touch it. In that case, you keep the applicants in prison forever. My answer is that this sound and trusted court will not say yes. About the last one, two. My lucky friend, Miss Amusubut, did say that by necessary implication, the Supreme Court validated, actually she used the word validated the pre-existing warrants. No. The Supreme Court said the trial is a nullity. Which lawyer doesn't know that a nullity is a nullity? The Supreme Court knows, like you and I know, that a nullity is a nullity. It cannot be the foundation of any lawful action. Therefore, no amount of validation and resuscitate that demand and this action. With respect to the case she cited of Arabas, governor of Brixton, especially his party now, I have read it. I think I read it before, but I can refresh. Specific reference was made to a lower court. There is no lower court. Because at the time it was done, it was valid. This case is distinguished. It has never been valid. The decision of the Supreme Court, and I find solace in the fortification of the decision cited by Mr. Samuel Besigye. If it is a nullity, nothing can be founded on that action. And besides, even assuming that it was a valid warrant, it expired. Under what case number, in which court are these people being held? There is none. The word is a remand order, and that is the cornerstone of legality. It does not exist, and it cannot exist because there is no case pending. You cannot issue an order. You cannot issue an order at a non-existing case. As you go and be detained for the next 1 hour. No. Finally, my Lord, we must not leave this kind of liberty to the detainer. The Constitution did not intend and did not give it. And who is currently the detainer? Currently, the detainer is the landed Attorney General, Honorable Chirewa Chwanuka, the Attorney General, because he's the one telling these people, you can continue to detain. The detainer can only keep court in a matter properly placed before court. The emphasis by my learned friend Amusu that we have a justification and therefore so to get solace in the decision of R versus Governor Supra by saying once they have what she called a substantive basis is a recipe for disaster. That once the state thinks they have a substantive basis, they can detain you forever. My Lord, even if the Attorney General says they are concluding this process today or even tomorrow, the detention remains illegal. It has been brought to your attention, my Lord. No excuse of administrative process can permit any further detention. I think they have even sought to intimidate you by saying the order you give might amount to contempt from court.
No, if it is about interpretation,
Yes.
for the media,
My Lord,
it's been coming to my inbox. Yes,
for the record, my Lord, my camp is this court. My client is in prison. Unless he received that message from his wife.
one message says my days are numbered. They don't see the light of tomorrow. But
I want to break that curse in Jesus' name. At least that you do not leave before you give us this body. But on my part, my Lord, I can only say we have no camp. I represent them.
I will do the proof.
Most appreciated.
That's the data was given.
Most appreciated, my Lord. I'm only saying, as Amos said, that if you give a decision as prayer, it will amount to contempt of the Supreme Court. The Supreme Court has never made a decision of continued detention. If anything, like you did right earlier, the Supreme Court restated and protected the Constitution. That one is your solemn duty to protect the Constitution. We should come here equal before you and before the law. Here we are coming with a recalcitrant detainer saying, as long as I have no decision of the Supreme Court to say release, I will detain.
That one is difficult. Can you split it down? I'm doing it deliberately so that if the phone is a bad one, we are bad.
Of course, I must apologize, but not with this age. By the time I went to school, we were learning difficult words in the eyes of some, ears of some other people. But I must say, you have a non-compliant and delinquent detainer who does not want to listen to the law, the command of the law. That's why I'm saying that this is a person who is maybe outside the courtroom would call it. I use a smaller one.
You know, what we are going to say outside because it's
Okay. In court, my lord, it is primitive arrogance for a detainer to say, I will not release until I have an order. Thank you, my lord.
My lord, 1 minute enough. I'll start from where my colleague stopped. We've dwelled so much on the administrative issues of the delinquent detainer. And my submission is that nothing done was supposedly done by the Attorney General, not even the DPP, constitutes justification for the applicant's detention. But for brevity, in as far as the misconceived submission
For anyone struggling with dementia, do not drink cold water. You've probably heard that memory loss is all about aging, right? You might think that
Human rights groups are demanding the immediate release of Uganda's opposition leader, Kizza Besigye, lawyer Aaron Kizza, and others who are in military detention.